Okay, welcome everybody. Today we have Jennifer Ellerd. She's an agent in our office. But today, one of her specialties is probate. You've been in the probate field for how many years, Jennifer?
Since 2005.
2005. So she's going to give us kind of a rundown of what probate is, how it works, and where she specializes, and as agents, what we can do and not do. And she's just a valuable resource. So when I come across this stuff, I'm constantly on the phone with her. I think right now we're in the process of two right now, and we just closed out 2 recently. So she's constantly in my world, and this is just a great source. This is a place that's growing in business right now. So I'm going to let Jennifer take it away. Go ahead, Jennifer.
Okay, well, good morning, everyone. Let me start first of all. Probate is a process where someone petitions the court to be the personal representative, either the administrator or the executor, depending on what's going on in the decedent's world or went on. And the court gives them authority to marshal the assets, sell the property, and distribute the property. So first questions that you ask for probate for your clients is, did the decedent have a will? If they have a will, then we need to find out who the executor is. That is the person who is in charge, who can go to court. So if the decedent had a will and your client is not the executor, that is not your seller. The executor, the person in charge, the person appointed through the will, is your seller. If there is no will, that is called dying intestate. If you don't have a will, the state of California has one for you. They determine who can be in charge of the estate. Again, who your seller would be. There's kind of a table for it. So first it would be a spouse, if there is one. If not a spouse, it would be a child. So if there's multiple children, they all have equal right to be the administrator of the estate. So the person that you're speaking to, again, if it's a child, may or may not be your seller. It depends on if the other siblings appoint that person. So just keep in mind when you're talking to someone, you want to get to the bottom of these questions first. So you know if you're talking to somebody who has the authority to even sell the property, or if you maybe need to go to a different family member. If there's no children, the table kind of goes on from there. It would then be a parent, and if there's no parent, then a sibling. So, if you get to that kind of situation, feel free to reach out to me and I could kind of guide you through that table. But again, that would be the first step for you as an agent, is to find out who the person with authority is. Once we get to that point and we know who you're talking to, there's paperwork that has to be prepared. So in order for them to get appointed and you to be able to sell the home, we're going to need the decedent's death certificate. We definitely need to check title to the property. So that's one thing that I see a lot of people not really doing, is they just make the assumption. Reach out to your title company, maybe not get a full preliminary report, but find out what the vesting deed is. Find out, did that decedent own 100% of the property? Did they only own 50% of the property? You need to find out. You can sell the whole house. So again, if you get to a situation like that where they maybe only had a certain percentage, feel free to reach out to me. Keep in mind that every probate is different. Like I said, I've been doing this since 2005 and I've never come across one that is exactly the same. For example, I worked for an attorney. I did her probates and her paralegal didn't know how to do it. And so we did 2 probates together, and then they said, oh, we don't need you anymore because we have all of your templates. Okay, no problem. And now I'm getting lots of phone calls. How do I do this? How do I do this? Well, the template, there's no simple template for it. So there's simple forms, but they're all filled out the same way. So it's the same as like our listing agreements. It's the same form, but not every box is marked the same way every time. So keep in mind, it's the same with probate. So once we get
Jennifer,
all of,
a
go
quick
ahead.
question. Difference between will, trust. I always see a lot of people asking the difference between, like, I have this will, so I'm good.
Okay, so the difference, let's rewind. So if you have no will, no trust, nothing, that's intestate. That means you have nothing in place. You don't have anyone appointed, and you don't have your beneficiaries designated. So the state of California decides that for you. If you have a will, that does not avoid probate. The only thing a will does is now you've appointed someone to be your executor who is in charge, and you've made a list of your distribution, who you want your assets to go to. It still goes through probate. If you own property, and this is for the agents individually too, if you own property, best thing, have a trust. So if you think of the trust is like a business. So you are the settler or the owner of your business, and you're also the trustee, which is like a manager of your business. So you take your assets like your home and you put it in the trust, which is putting it in the business, and now you don't own it individually. So when you die, a probate is for an individual person. Your trust avoids probate because it's owned by your trust or your business. So you have a successor trustee, which is like a kind of a successor manager. So when you die, that new manager comes in and can go in, distribute, and dissolve your business, and that avoids probate. So that's the difference. If you have a trust, that's great. When someone dies, you do what's called an affidavit death of trustee. It takes them off title, puts the new trustee on title, and immediately they have authority to sell the property. So a trust is always the best scenario, especially for us as agents, because that means we can sell the property right away. As soon as the affidavit is done and recorded, you have authority. Probate, wills, not so much.
And what is the time frame from the time that someone says, I want to sell this house, I need your services? What are we seeing in terms of time frames?
So post-COVID now, it's taking a lot longer because the courts are really impacted. So for example, on the 24th, Stanislaus County completely shut down all of their window services to the courthouse. And so things are going to be backed up even more. I haven't been up to Stockton, so I don't know about San Joaquin. Generally, it usually takes people about a week or so just to get me all of the right paperwork. Takes me about a week to prepare all of the paperwork because it's several documents. And then once you file it in court, it's taking between 45 and 60 days just for your hearing. Now, usually about a week to 10 days before, we get what's called probate notes. And that says, is all of the paperwork satisfied the court, or do they require additional information? Because sometimes they do. If all of the paperwork is satisfied, then within that 45 to 60 days, and you have your hearing date, generally someone gets appointed, that's when they can sell the property. If the paperwork has not satisfied the court and you need additional paperwork, they're pushing your hearing dates out. Ron and I just had one. It was just this past week. Unfortunately, all the paperwork wasn't in order. The hearing date now is in June. So it's taking a long time.
And during that time, the mortgage is still getting, if there's a mortgage, the bill just keeps racking up higher and higher and higher. Utilities, all those things.
Right.
This one, I think, has tenants inside.
Right. And unfortunately, when no one's appointed, you can't do an eviction. You can't do anything because nobody has the authority to do anything. So this tenant for Ron's client is just sitting there rent free, living in this house. It's really unfortunate, but the administrators, because there was no will, there's two administrators. They both live out of state. They both live in different states. And so now the court is imposing a bond on them. So there's a lot of other things going on. Like I said, every probate is different. And so now we have to see if we can get a bond for these people. And this is just, unfortunately taking more time.
What is the cost of a probate from an attorney standpoint compared, and then what is the cost that you charge? Because there is a difference, and who sets that cost?
So keep in mind, there are fees and costs, and they are separate. So let's start with fees first. $435 to file a petition for probate. in court. That's standard throughout the state of California. Some counties, every county is different, may charge an additional fee for a court reporter. Some charge like 35, some charge 50. It depends on the county. Thankfully, Stanislaus and San Joaquin do not impose that fee. Once you pay the $435 and petition the court, you have to publish it in the newspaper. Publication is different for every newspaper. The Stockton Record's $899. I think the Tracy Press is $250. The Denair Dispatch Houston Chronicles $175. Modesto Bee's $536. So that is determined on, we need to look at the death certificate, see where the person passed away. Courts have what they call adjudicated newspapers, so it has to be a newspaper approved by the court. So there's that cost on top of it. Then there's a probate referee, which is a court-appointed appraiser, and they value the property. They get paid a fee. It's a minimum of $75 or 1/10 of 1% of the value of the estate. Then when there's a house to sell, you have to get a certified copy of the letters. That's $40.50 with the court. Then you have to record it. So depending on what county it is, there's a recording fee. Then there's also the option for creditors to come in. You have to notify all creditors. And we're talking Verizon bills, ambulance, medical, every creditor. They have 4 months to file a claim. If they file a claim, it has to be satisfied. So who knows, if you have a between $3,000 and $5,000 credit card bill, that has to be paid or satisfied. Let's see, from there, when you petition for a final distribution, it's another $435 because it's another petition. So all of that is just the fees. Now the costs for an attorney are their statutory fees imposed by the state of California. They have a table. It's 4% of the first 100,000, 3% of the second 100,000, 2% of the next 800,000, and then it goes, beyond there. Keep in mind, the fee is, they look at the inventory and appraisal, which is what the probate referee values it. So say the house is 300,000. Now they may only have $100,000 equity, doesn't matter. The court looks at it, 300,000. So you're paying the attorney $9,000 straight, no matter what. And so that's really unfortunate for people who are probating a $300,000 house and they want to keep their family home. If they can't afford to pay the attorney fees and all of those costs, they're forced to sell the home just to get it out of probate. As far as my fee, I charge 2% of the value of the estate. It's not the 432, it's just a straight 2%. So I generally ask for $500 up front to get started, $500 once they get appointed to push me through, the rest of the year, and then the rest at the very end when we petition for final distribution.
So people do have options, they just don't know. Usually what I find when I'm talking to clients, this is just above their head. They are so intimidated by the courts. They're dealing with grief, they're dealing with emotions, and they are making emotional decisions, not logical decisions. And that's where I think the best value we bring to them is, here's options that you have that you didn't know you have. And my job is to be your guide while you're not thinking logically. That is my goal, is to think logically for you and show you all your options so you can make a good decision for you and your family.
Correct. So another thing, if you're doing something, stop what you're doing, look up, pay attention. This is very important for every agent. This is going to be the most important piece of information I'm going to give you. So get a pen, pay attention, super important. If you are meeting with a client and they have a probate house to sell, chances are they may be interviewing other realtors. You're not going to be the only one. If you want to edge out the other realtors, listen. You must tell them. Generally, attorneys charge what's called extraordinary fees. When you sell a house, that's above and beyond the scope of the probate. So attorneys can charge an additional $150 an hour for the sale of the house. If they have a realtor who does not know what they're doing and has to call the attorney and say, could you look at my forms? Can you do this? Can you do that? Every time you as the realtor calls the attorney, your client is being charged $150 an hour. If you send them an email, if you do a 2-minute phone call, they're charged 0.6 minutes. So the less you know, the more your client is getting charged. So if you can tell your clients, I'm aware that attorneys charge this, I will not be calling the attorney a million times. I know what I'm doing. I don't need them to review my contract. I know that I need to have a probate addendum. I know that I need to have a representative capacity declaration. I know that in my confidential agent remarks, I need to say this has to be a probate purchase agreement. Don't worry, I won't call your attorney. I won't ask all these millions of questions. Now tell me, how many other realtors are going to say that to the client? None. And they're going to be like, wow, this person knows what they're doing. You can also let them know, once we sign this agreement, it is not effective today. Realtors do not know that. In a probate, your purchase agreement must go to the attorney. They have to do what is called a notice of proposed action. That notice goes to all of the beneficiaries. The beneficiaries have 15 days to either consent or object to the sale. So you could do a listing agreement, put it on the market, get in contract in 5 days, and one of those beneficiaries may object and say, no, I want to buy this property. Guess what? Bye-bye escrow, because that beneficiary has more right to purchase the home than your buyer because they are a beneficiary. So they have 15 days to consent or object. So you let your seller know, we're going to prepare this. I'm going to get it to your attorney. Once the 15 days has lapsed, then we can put it on the market. Now there are ways around that. And this is another part where you could be the agent who knows what they're doing. You can tell them. Now, if all of the beneficiaries are willing to sign a consent saying that they want to sell the property, it waives the 15 days. If there's 3 beneficiaries and 3 beneficiaries sign that consent that day, you can put it on the market that day. If even one says no, you have to wait the 15 days. So keep in mind those little pieces of information I just gave you. If you tell that to your probate client, they will realize, wow, this person knows what they're doing. Because again, chances are another agent isn't gonna have this probate knowledge and isn't gonna know this stuff. So when they interview someone else and they might ask another agent, well, what about the notice of proposed action? The other agent's gonna say, what are you talking about? Light bulb's gonna go off. Oh, I should go with that other guy because they know what they're doing.
Hey, Jennifer, could you say that just a quick second? I was taking notes. So the 15 days at the beginning, that starts, can you go back? I was kind of scribbling.
Okay, so you do your purchase agreement so your listing agreement, you send that to the attorney. The attorney prepares a notice of proposed action and mails it to the beneficiaries. That 15 days starts when that attorney does that notice of proposed action. So you want to hopefully make sure that that attorney doesn't sit on this for 3 or 4 days.
Got it. Okay, so that means the other beneficiaries have 15 days to speak up or forget it.
Right.
Okay, got it. Okay, now what if the other beneficiaries are minors?
That's where things can get a little more complicated. Sometimes at that point, the court would have to appoint what's called a guardian ad litem, and the guardian ad litem would have the opportunity to consent or object.
Got it. That would be basically another attorney representing the minor.
Yeah.
Got it. Okay, good. And if it's in my situation, I have you know a little bit about this. It's the daughter whose mother would be the next adult in line, and her son who's an adult, but his capacities are at question. Now it's like, what do we do? So the mother is just paying the mortgage for the last 2 years.
Right. So unless they get a guardian ad litem.
Yeah, he's of age, but now they have to find out capacity.
Right.
Okay.
Okay.
Should be calling you.
This just because for probate. So if we have, if you already have everything filed already and you're good to go, don't need court confirmation that you can go and sell it. If there's a will, if there's a trust in place and they've already changed the name on the title to the successor trustee, then we don't need to wait that 15 days. I mean, wait the 15 days in.
Yeah, for a trust, the 15 days does not apply for a trust. That's only for probate because that's court.
So then, so for probate, if you have a listing agreement, you have a date of right when you're going to start, when it ends, when it's going to be on the market. That's going to be kind of sticky, huh? Because you have to wait on here.
It is. Also, keep in mind, pursuant to the probate code, you are only allowed to list a probate property for 90 days, not 6 months, 90 days.
Right. So how does that change on our dates for that? I mean, do we not date it then and let the attorney approving and then date it, or you have to date it and then wait?
I wouldn't date it. I wouldn't date it until I can actually put it on the market, because you're going to lose 15 days and you only have 90.
Right. Okay. Sounds great. So the best thing is just call. If we have a probate property, just call you.
Yes. Yes.
Hey,
Now,
Jennifer, what
I second
happens,
that.
what happens to the mortgage when it's not being paid? Can they be foreclosed on during that period of time?
they can, and unfortunately, I had it happen before because they hired an agent in Stockton to try and sell a property in Merced, and that Stockton agent never drove down to Merced, never put a for sale sign in there, and they lost the house.
I think I remember that one. That was the acreage, correct?
Mm-hmm.
I remember that one. Yes.
Yep. It's really, really a sad situation, but yes. Now,
Can you
also keep in mind that.
So the question that Ron brought up, when it's someone passes and they're like pre-foreclosure, so they can still foreclose on the property and not have the opportunity to sell it beforehand?
That is a possibility. Now for me, so for my clients, because I've had a couple that are pre-foreclosure, the first thing that I do is I write a letter to the foreclosure company saying so-and-so has hired me to do the probate. Their intent is to sell the property and you will be paid upon escrow as soon as they're appointed. Usually when you communicate with them, they work with you, you know, their ultimate goal is to get paid. And if they go through a foreclosure, they're paying for foreclosure. So if they can avoid that, they're willing to work with you, but they're only willing to work so long. So if you have a seller who's just dragging their feet and like, oh, well, my mom died in 2018. Oh, well, I don't know what we're going to be able to do because it's been a long time. So
Yeah,
oftentimes they will work with you if the attorney you work for, someone like me, writes a letter, you know, I've been hired by this person, we're administering a probate. And then again, once the probate gets started, you send them another letter. We've started the probate. Here's a copy of the petition. This is our hearing date, just so they can see that we're going. Then again, my client has been appointed. Here's a copy of the letters. They have authority. They're selling it with this person. You write the name of the realtor. You know, it's in progress. Once you get an escrow, a contract's been, you know, reached. I mean, you're talking multiple letters to the foreclosure company, but if you keep them, you know, keep them in the know, then they work with you.
Yeah, one of the things that I've learned over the years is the ones that are communicating with the banks, they will not push foreclosure. It's the ones that don't communicate, put their head in the sands. Those are the ones that get foreclosed on. So if you're communicating, you're updating, you're letting them know what's going on, the process, give them realistic timeframes. I've had one that's gone out over a year that we've kept out of foreclosure. The bank got paid in full because there was plenty of equity, but it took a long time to do that stuff. They were fine because all they want to do is get paid in full and communication. So we kept them updated. We made sure that they got paid in full and everybody walked away happy. And that's the goal.
Right. Another thing I want you guys to keep in mind is there is full authority and there is limited authority with the probate. If you have somebody who is already going through the probate process, the full authority is the best because that means they can sell it, no questions asked. If they have limited authority, that's when you need to get court approval. That's when you need to sell it within 10% of the value of the probate referee's valuation. I mean, you can't go lower, higher, of course. So limited authority is a little bit more difficult. I think I've seen limited authority twice since 2005. It's very rarely happens. but it does happen. So keep in mind, if you do meet with somebody who is already going through the court process, has an attorney, ask them if they have full authority or limited authority. It'll just kind of help you make the decision as to what you need to list the property for.
Hey, Jen, back to the fees. The first
Yes.
portion of those fees were the numbers that you were doing. Those are non-attorney fees, right?
Correct.
And then there would be, like, for example, in your case, it'd be the 2% of value if they were going through you.
Right.
Those first set of fees they have to have the money to pay that to get it started. They would have to have some sort of resource to get a started, credit card, whatever, but they got to pay
Yes.
those fees. That's not something that gets paid at close of escrow, correct?
No.
Got it. So the rest of your fee is at close of escrow, or?
Generally, I do it when we petition for final distribution at the end.
Okay, just for me to get an idea of what they can expect, I would most likely, in
Right.
this case, have a conference call with you and just kind of listen in that sense, but having the resource. Okay, cool.
Right. So the first fees they need are, for me anyway, is $500 up front to start the process, $435 for the court filing fee. And then I would have to see the death certificate, look at the adjudicated newspaper and see how much that publication fee is. And then that would be their total fee.
Got it. So in the sounding of that to me is like, it's not that horrible in this sense of going through you. If you went through an attorney, there's a whole bunch of other drama you got to do on your own, but I mean, it's not horrible to go through you at all. I just mean that going this route is a smoother way of doing it. So, because I probably have 3 of these coming up. I didn't even realize, but they're turning in that direction.
Right. Now one thing with attorneys though, so with their statutory fee, they don't get paid till the very, very end. So they don't charge 500 up front or 500.
Mhm.
They're not allowed to,
Mhm.
but they get paid more than I do. So
Right. They'll get paid more later. Yeah.
they'll get paid more later. So,
Right.
you know, and they can charge those extraordinary fees to sell the house. I don't charge extraordinary fees.
Right. Got it.
I will tell you, having worked with attorneys, when it gets close to the end, believe me, they put a lot of pressure to get things done. And because they want to get paid, and you know, they've been carrying this for months. So this is, they're counting on that check to come in. So keep in mind that even though they don't get money up front, they've wasted money on staff, time. And so they're anxious to get that check coming in. I mean, they're calling and emailing going, hey, when are we closing? When are we closing? Because they want to wrap this thing up.
You talking about attorneys or realtors?
Attorneys.
That was a joke.
Yeah, attorneys.
That sounds like realtors to me.
Hey, attorneys are just as broke as realtors are. When you get to know them, you realize it's kind of comical. They're not as rich as you think they are.
Mhm.
Hey, go ahead, Jennifer.
I'm not sure. I don't know where to go next. I don't know what else anyone wants to know. This is kind of the probate is more of a process than this, but as far as what you guys need to know, you know, this is kind of the overview of what you get to be able to get to the point where you guys can sell the house. Now, once the house is sold, if you just want to be able to tell your client, so you know the process, you know, once the house is sold, it gets put into an estate account and they do not have access to the money. So keep in mind for that. You know, once they get appointed, you guys can sell the house, but we have to do that notice to the creditors that I was talking about. And they have to wait 4 months for any claims to come in. And if claims come in, they have to be satisfied. So that money has to sit in an account for at least the 4-month time frame, or until the time for the creditors' claims to that 4-month statutory time for it to expire. After that, if there's no claims, then we can petition for a final distribution, but that's another petition. Now you're waiting another 45 to 60 days for a court date. And so again, they can't touch the money until we have that hearing, and then there's an order, and then they can make a distribution. So as of now in the state of California, it's taking close to a year before they can have money. So they have to keep in mind, if they're living in the property and then the property gets sold, they can't count on that money to go get another place. They're not going to get that money until the court orders it. And you're looking at another probably 6 months from the time the house is sold until they can potentially get the money.
And the money goes into their bank account, or do they have to have a special account?
They have to have a special account. It's an estate account. So we actually have to get a tax ID number, which you need for title anyway. You have to have your order and letters from the court. You have to have an original death certificate, and you have to go to the bank, and it's the seller's name as administrator or executor of the estate of and the decedent. They cannot commingle the funds. So they can't put any of the money in their account. They can't take any of the money. The money has to sit there. And depending on what the other beneficiaries do, they may have to do a full accounting of every penny. And when I say every penny, a court accounting is very, very meticulous. There's a lot of different schedules. And one of the schedule is even, they want to know if there's 3 cents interest in that account in 1 month. I mean, they literally to the penny. And if your seller has absconded with some of that money, the beneficiary can get double damages. I actually had someone come to me. She tried to do this whole process herself, came to me when she thought it was time to petition for a final distribution because it was hard. And she already gave the money to all the beneficiaries because she didn't know. And then one of the beneficiaries died. And now his share goes to his children. She had to refinance her personal home, take money out of her home to put it back into the account because she spent all of the money and now she didn't have money to give to the other beneficiaries. And if she didn't, and it was double damages, then she'd be in even more trouble. So unfortunately, she had to take money out of her own house. And even though she already gave the money to the beneficiary, he died. And so the court doesn't acknowledge that. He can't sign a receipt saying he received the money, and the court never gave her the authority to give the money away. So it was a problem.
I will tell you, I've seen this work out really beautifully through probate. Everyone's happy. We just had a couple examples of that. And then I've seen the worst case scenario where families fighting. And I had a really good friend who went through this process, and wow, it wasn't even a family member, but they had some legal authority in there. He just drained him so much. It was horrible that what he thought he was going to get and what he ended up getting were completely different. And it was, and the guy just won because he had deeper pockets and he knew how to work the court systems. And my guy was not strong enough or smart enough to figure out how to do this. And he didn't listen to any of our advice. I referred him to you. And he's like, oh no, this won't happen. Well, it happened. I will tell you the worst thing that I see with this is families play dirty sometimes. And
Absolutely.
you will see that. You'll hear people not talk for years because of this stuff, because there is a power struggle between who gets what and how it happens. And it's pretty horrible. I mean, it's emotionally draining. I would say most of the times I take probates, there's a lot of crying involved. There's a lot of crying involved.
Yeah.
No.
That's true.
One of the things that I see a lot of is as they're going through the probate process, they're getting letters, emails, phone calls from investors saying, hey, I want to buy this house.
Right.
So as agents, how do we protect ourselves?
Well, first of all, you actually, once you do that publication in the newspaper, that's when the letters and calls start coming in to your seller. Keep in mind, your seller does not even have authority to sign anything at that point. So as an agent, you could let them know, look, if you're getting these calls, just tell the agents or the investors who are calling you, because the person's phone number is in the publication, I don't have authority to sign anything. I have not been authorized to the court. So you're talking to a wall.
Yeah. And the other part that I do is educate them is, your job is to do what's best for the estate.
Right.
If you sell to an investor, are you doing what's best to the estate? And can you defend that in front of a judge?
Right. You have a fiduciary duty to the other beneficiaries, if there are any, to get the highest and best price. So I actually have a probate right now, and we have a house right down the road from one of Ron's, and one of Ron's investors came in and, gave us a decent offer. But my seller, even though it was Ron's client, said, no, I can't just take the first offer. And so we waited, put it on the market, and we got $42,000 more than that offer. And we had to do what's in the best interest of the estate. So even though we could have had it, you know, immediately in escrow, probably closed by now and done, it is your fiduciary duty. So once the person becomes the administrator or executor of the estate, they are signing a paper under penalty of perjury with the court called duties and liabilities, saying they are, at that point, once they're the administrator or executor, they are an officer of the court, and it is their fiduciary responsibility to the other beneficiaries to do what's best for them, not necessarily what's fastest or what's easiest, but what's best. They have to protect that beneficiary's distribution and get them as much as possible.
Hey, Jennifer, what about the gray areas between the decedent and trying to get this done? So in my situation, it's been a big wide time gap of actually starting it. What the mother's been doing is paying everything, just whatever bill it is, she pays it, or paying it off, mortgage, taxes, all that kind of stuff. That brings another question of recouping, but I doubt that there's any recouping from anything she's paid. She's just been paying it. She didn't do the process early enough. But what about like her reaching out to creditors to and whatnot? Should they do that? For example, she's been paying the mortgage, but the mortgage has been collected. They probably don't even know the young lady's been passed away.
Right.
How does she say, hey, listen, I'm just letting you know I'm paying this? Does it even matter at this point? Because she's paying it, she's going to go into probate. Does that even, it seems like a gray area.
It depends on the mortgage company. Some of them technically can call the loan because the borrower is deceased. So, I mean, probably not going to happen in your situation because the person's paying it and at least it's being paid for.
Yeah.
But they can call the loan. They have every right contractually because the person that has the loan is now deceased.
Got it. Good. Okay.
I will tell you, having dealt with deceased people and paying mortgages on their behalf, most of the times, this is so automated, as long as they're getting payments, they never question it. They only start questioning when they're not getting payments. Now, just remember, if this was 40 years ago when you used to walk into your local bank and make a payment and the bank teller knew who you were, that's when they used to call it. Now with automation, it's rare that anybody does this. Remember, banks and servicing companies, they service millions of properties and they do it on a volume basis. Let's say they get $18 a house to service. They're doing this through automation. It's not one person taking that paycheck going, okay, does the address on the check match up to the address on the mortgage statement? It's just not done that way anymore. That's why I'm never really in fear of, you know, a loan being called due. Now, let's say interest rates jump up to 9% and you have a 3% mortgage. I think we might start seeing that at one point because they know they can get more money for that in the future. Don't know yet, hasn't been tested, but my gut feeling is they may notice at that point. All right, any other questions for Jennifer?
How about process? I mean, we're talking about this and now, you know, we're all aware, we're much more aware. So how do we, I guess, how, is this something we pitch? Is there a pitch to this from a sense of services that the brokerage has at our fingertips? I mean, I'm sure it'd be as simple as saying, hey, we got somebody in house to do that, but I think it should be much cleaner than that, than just saying, hey, we got someone in house that does that. So how do we, I'm trying to think of how to ask the question, really. Is this something we want to talk about, or we want to say we have, or only when it arises? Or is it something, you know,
I think if you're going to go market this, there's a lot of people that market this all the time. And they come off as ambulance chasers for the most part, right?
Right. More of like in conversation, if it's.
Yeah. So here's the goal behind this whole thing. Are you educated? If you're educated, then you can have real conversations. If you knew what this was, if you knew what the process was, if you have enough that you can ask the right questions, then you can have real dialogue. And I will tell you that first one or two that you don't know, bring someone like me along that's been there before.
Yeah.
A, you're going to get an education, but B, you're doing the best service for your client.
Right.
First part is you fumbling through this, and it's a horrible experience for your client, and your client's just going, who is this guy? Like, he had
Right.
no clue. I knew more than he did. And it's the worst case scenario. The reason why I'm doing this is I want you guys to feel educated enough to ask the right questions, and you guys are topical about it. Now, once you get beyond that, hey, I can help you, let's set up a time, that's when you bring in professionals to come in and help you.
I
Because
think that's more of where I was trying to get the question. I just couldn't get it out. Is that kind of like not clearly knowing that this is something that you and Jennifer should kind of get going, get it started and whatnot. And I just was like, okay, well, what happens if we are overburdening? Do we kind of, I don't want to just throw it over the fence, but like, hey, Jen, I don't know this. Do I have them call you right away? Do we, here's who you call? Like for example, when we have a
You can have them call me right away, or if you
Yeah.
know you're gonna meet with someone who has a probate sale, shoot me a text. Hey, Jen, I've got an appointment with somebody on, next Friday at 3 o'clock. Can you be on standby for a phone call? Absolutely. And then when
that's
you
what I
get there
mean.
with your client, and if there's questions that they have that you can't answer, that's when you say, you know what, we've got someone at Home Buyers that I can call who can answer these questions for us.
That's what I mean. I couldn't quite get that pulled together. Like, okay, are we going to start funneling all these people and you get run over with all this noise? Or that's what I mean in that direction. Yeah, because I'm not even touching this right now. This is not even
Right.
my, yeah.
Jennifer,
Right.
what kind of documentation should they get when we go meet them?
If a probate is needed, probably too much. There's probably too much for you guys to ask.
Can we get a Jennifer flyer?
It's quite a long checklist.
Can we get a little
Okay.
Jennifer rack card or flyer? Like, hey, I'm not even going to say, Jack, here's a service we provide, and let's schedule an appointment with Jennifer. And do we have like a company flyer we can put together? That would
No,
come.
I don't think, I think it's too in depth. I think what usually happens is conversations. The work.
We can't get one of those Bill Fogg
Yeah.
signs that says when something's wrong, call Ann Fong. We can't get that.
Yeah. 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 So what I usually do is I usually ask for mortgage statements up front,
Yeah.
just to get a feel for where they're at, because sometimes you might get a mortgage statement and they owe way more than the property's worth.
Yeah.
And then you have to make that assessment. Does it make sense to do a probate? Because there's fees involved and it doesn't make sense, right, Jennifer? Like we were looking at one in Stockton. That's what one of your
Right.
clients.
So I had another investor who paid me up front to start a probate, and unfortunately he didn't do his due diligence in researching the property. And we got the probate started and appointed, and he went to purchase the property, and she owes more than it's worth. She had like 2 mortgages.
Woo.
And I had Ron go in there to see if there was anything, and even Ron's like, there's nothing we could do. She owes way too much money. So you need to do the research. You don't want to get somebody's hopes up and then be like, oh, sorry, like that's a bummer. So but again, it's really hard. It's not every probate. There's not a one size fits all. And to be honest, I don't, like Ron was saying, you don't necessarily want to do a card, because I feel like that would almost be like an ambulance chaser. Like, well, here you go. That's what we're here for. It's better when it's more of an organic conversation. Like, well, let me get you in touch with somebody. If you have like a flyer, it's like, oh, we were just waiting for you to say that. Here you go.
Okay.
Yeah, I always start with, I go there and I just listen and just hear their story. Here's what they need to get this off their chest. And when they give you their story and you actually listen, that's the best selling you'll ever do.
Mm-hmm.
You don't have to say a thing. They just want to be heard. And then you start finding the solutions after you've heard them. But if you don't ever hear them, then you're just another salesperson. Stop being a salesperson. Listen.
And Ron just said a key word too: solutions. Once you listen to everything they say, phrase it with that word. Okay, I see you've got a problem. You have a probate that you need to do, or you have a trust that needs to be administered. I am your realtor, but I want to help you find solutions in getting all of this taken care of. Use those kinds of words, because then they're going to look like, oh, solutions. They want to help me. They don't just want to sell my property and make money. They want to help me with the process. They actually care. You know, and that's one of the reasons, honestly, why I left the law firm, because most attorneys, not all, but most attorneys look at somebody as a file number, not as a person with a soul, a living, breathing person. They just, let's get through the process and make the money. But once you tell them, no, I'm here to give you a solution. I'm here to help you with the process. Give me some of your burden and let me help you. Let me shoulder some of that for you, because that's what you're paying me to do. They're just like, oh my gosh, right there. When I say that to my clients, the sigh of relief that they get, like, you want to shoulder some of my burden so I don't have to deal with this on my own. That's a selling point instantly. Now I have people love me. Oh my gosh. You're like an angel. I can't believe you're here to help me. Yeah, I'm not just here to make money and give dollars. I'm here to help you as a person. This is a process we're going to go through together. That's a selling point right there, especially when it comes to probate or trust administration, because like Ron was saying, it's very emotional and that person is sad and upset. And when they have somebody who can help them process that emotion and create a solution to this whole grieving process, people just take to that like nothing. Like, you wouldn't believe it. They love it.
Nice.
Awesome job, Jennifer. Thank you, thank you, thank you. All right, I'm going to stop
Any
the
other
recording.
questions?
Thanks, Jennifer. Amazing.
Okay, if you guys don't have